Hi everyone, welcome to another episode of Moving to Australia podcast with Amitava Deb. In today's episode, we will talk about how a business in Australia that has a genuine need to fill a skilled position can become eligible to sponsor skilled workers from overseas. Welcome to the podcast, Amitava. How are you doing?
I'm good, Arun. Good afternoon. Welcome back after a couple of weeks, I think.
Yeah. So, how you been handling the weather?
Very cold. It's unusual. This time of the year is usually cold, but this year has been really cold. But I like cold weather. I'm sure you do as well.
Yeah, I do.
In this cold weather, I'm going whale watching tomorrow off the Sydney Harbour. This is one of the things those who come here must see.
I hope you know how to swim.
Yes, but I don't think it really helps. But yeah, that's not a prerequisite.
Well, enjoy your time with your family.
Thank you.
So let's dive right into the podcast. So let's start by addressing a common question that you have from a lot of employers, businesses in Australia, is how can an employer be eligible to start sponsoring employees from overseas?
Well, there are a lot of employers who have difficulty sourcing the right talent from the local market because of certain skills requirement and availability of resources to meet their demand. So there is a process through which an employer can start looking for applicants offshore, skilled applicants. For that, the first step would be for the employer to apply as an eligible sponsoring employer.
Okay. So what are the various types of sponsorship options that an employer has?
Yeah, so the most common one is the Standard Business Sponsor, SBS, and that is used for the TSS visa, subclass 482 for both medium and long-term stream. The streams are decided by the occupation. And then there is a labor agreement. Labor agreement stream is for specific occupations. They may or may not be covered by the standard skilled occupation list. And hence there is a need for industry-specific agreement. There are already some standard templates available with the government. The employer enters into either using one of the existing templates or a new template and get approval from the government to be an eligible sponsor under labor agreement.
Okay. Now, you mentioned that there's a lot of subclasses and streams for both options. So
Yes.
what are the various employer-sponsored visa subclasses and streams?
It depends on whether it is a temporary sponsorship or a permanent sponsorship, PR sponsorship. So if it is temporary sponsorship, we have subclass 482, which is the most common one. It is also known as TSS visa or temporary skills shortage visa. And as the term implies, it is only to fulfill a temporary requirement of filling the gap. So the expectation is that person who will come on a TSS visa will upskill the local workforce. So that is this 482 TSS visa. The other one is employer nominated sponsorship for PR, ENS, and that is subclass 186. There's also subclass 494, which is the regional sponsored employer sponsored visa. And the employer must be in a regional area, and that also has certain requirements, but it is a temporary sponsorship, like TSS.
How many streams does the 186 have?
186 has two streams. One is the direct entry, and another one is the transition. Transition is for someone who goes through the process of being in Australia on a 482 visa for 2 years. Now earlier it used to be 3 years, and for 2 years now. And then they apply for the transition stream employer nomination scheme visa, ENS visa, subclass 186. The other stream is direct entry. For direct entry, there is no requirement for the applicant to be on a 482. However, they need to meet 3 requirements. One is they must have at least 3 years of experience. Secondly, they must have functional English. And number 3, competent English. And number 3, they must have a positive skills assessment in the occupation they nominate.
Is the 186 a permanent visa, or is
Permanent
it a
visa.
pathway to leading to? Okay, it's a permanent visa.
Permanent visa.
And you mentioned a third one as well, right? Which one was that?
494.
And if someone's on a 494, that's a temporary visa again.
Yep, and then they
How does one become a permanent once
after
they're on-
3 years they can apply for subclass 191 visa,
Okay.
which is also the pathway from the current independent subclass 491 regional visa.
Gotcha. Now, can an employer sponsor someone who is already in Australia?
Yeah, the applicant can be in Australia, can be overseas. It doesn't matter. If the person is already in Australia, they must be on a visa that has no bar on applying onshore for another visa. And until the sponsorship is approved and subsequently a visa is granted, the employee cannot start working.
The amount of paperwork involved for someone who is offshore and onshore, is there a difference in that?
It's more or less the same. The only difference is that when someone is onshore and applies for this, they will get a bridging visa. But note that it's a 2-step process. First, the employer has to apply for nomination. Once the nomination is approved, then the employee applies for the visa. So it's nomination and visa application.
What is the time frame for an employer to become eligible as a sponsor, to sponsor an overseas worker?
Usually it is 2 to 4 weeks once they apply. And to apply, they will need to provide evidence that they are operating, provide evidence of their last financial returns and recent business activity statements, and non-financial document, like, for example, lease agreement of their premises or organization chart or even a business plan.
Now, this time frame that you mentioned, 2 to 4 weeks, is it the same if the employer opts to get into a labor agreement with the government or chooses the other route?
If it
become a
is labor
sponsor?
agreement, it's very, very quick.
Faster than 2 to 4 weeks.
Faster, yeah. It's usually decided within a week.
Is an employer in a position to transfer sponsorship of someone who is already sponsored by another employer?
Yes, of course it is possible. And it happens all the time because just like in a competition in any field, there's a competition to get the right talent by the employer. Hence, an employer will always offer, make indecent proposals to attract the right talent, and then they can transfer the nomination to their company. The funny thing is that to transfer the nomination, if you have an existing employer sponsoring you, you do not have to take permission. You can just approach another employer who is ready to sponsor you, offer you more money, and once the sponsorship transfer is approved, you can say bye-bye to the existing employer.
Was this always the case, or has this been a recent change?
Always the case. Employers are aware of this. Hence, a lot of employers try to probably make some kind of arrangement. However, when they do that, when employers do that kind of arrangement, meaning, asking them to pay a bond, that could be illegal. So what I suggest a lot of employers is that instead of taking some bond, which is not allowed maybe in the Australian employment laws, they could maybe hold a loyalty bonus at the end of certain period. You complete 1 year with me, with our organization, we pay you this amount.
Any skilled migrant who wants to educate himself or herself against these malfeasance that employers get into,
Mhm.
exploitation
Mhm.
that you spoke about, where can they get more information about this? Is it available on the government website? What their rights are when it comes to working in Australia?
There are two things. One is the rights with respect to the workplace
Yes.
and employer relationship. The other one is the law with respect to the migration process. So the uh, migration regulations prohibit the employer from taking money to provide sponsorship. It is not allowed. Sponsorship always has to be paid by the employer because they have a genuine need, not because the employee needs the job. It's the other way. Of course, the employee needs a job, but it is initiated by the employer because they have a genuine requirement. Hence, they are the ones who should be paying it. Otherwise, there's going to be exploitation.
Is there more information about a person's right to work in Australia available on the DHA website, or is it at
Right to Australia, working rights to Australia won't be in the DHA website. DHA will be mainly around the migration regulations, but they can look at the workplace relations.
Will the taxation office have it? ATO website, you think?
I think you can Google workplace relations.
We will have that information in the description of the podcast, so you don't have
Mhm.
to scour the internet for that.
Right.
Are there any differences in the list of occupations that can be nominated
Yes.
for employer-sponsored visas?
Yes, of course. The occupations similar to what we have for skilled independent migration. There is the medium to long-term skills list and the short-term skills list. Medium to long-term skills list have access to subclass 189, as you know, which is an skilled independent visa. And short-term skills occupation list, they only have access to state-nominated migration. Similarly, for employer nomination, for 482, there is medium-term stream and short-term stream. Medium-term stream has access to only the occupations in the MLT SSL. Short-term stream is for occupations in the STSOL. There's a difference. Those who are on the short-term stream, they have to write a GT statement, Genuine Temporary Entrant statement, that their purpose of staying is temporary and then that they will go back. For some reason, this is something that is required only for STSOL stream occupations or STSOL stream 482. It is not required for the long-term or medium to long-term stream. Although it is a short-term visa. I thought I'll just mention about this.
Can someone who is being nominated, their application be declined based on this test that you just spoke about?
The stream, you mean? No.
Not the stream. The genuine eligibility.
Genuine temporary.
Temporary, yeah.
Oh, it's a write-up. It's a write-up which you have write. I will be going back. I hereby declare. It's just a write-up.
But there's never been a case where a case officer was not convinced by what you...
They're going to get rid of this requirement. They already got rid of this GT requirement in the student visa. Now the new requirement is genuine student requirement, GS.
Yes.
So it's more of a tick in the box saying I have met this requirement. Something else which I have not spoken about is the labor market testing.
Yep.
So all these temporary skilled visas must undergo a labor market testing, which means the position must be advertised in at least 2 media in the last 4 months for at least 4 weeks.
Can you define media?
Media can be electronic media like a portal. It can be a radio.
Okay.
It can be a newspaper, print media. But these days everybody uses job portals. It's not easy to get hold of a radio station and advertise.
And how long does the job need to be advertised there?
For 4 weeks.
4 weeks.
4 weeks in the last 4 months. And then they have to demonstrate that out of all the applications, they were not able to find someone more suitable than the one who has applied or they have selected.
Are there any rules to how they can demonstrate that?
Yes, well, not rules, some guidelines. And I have a template, which I always use. However, having said that, there are certain countries, if an applicant is a passport holder from a country that has a trade agreement with Australia, then labour market agreement is not required. So these countries include a lot of these Asian countries, Singapore, Malaysia, etc. And then UK. There are a few South American countries like Chile. India, there's a trade agreement with India, but I don't think the labour agreement is exempt for Indians yet.
Okay, we'll keep an eye on that. If anything changes, you will know about that.
Yes, absolutely.
On our website or on the podcast.
Mm-hmm.
Now, is there any difference between employers located in a regional area and employers in major cities when it comes to sponsoring visas for skilled workers?
Yes. Certain subclasses are only for employers located in regional areas, like subclass 494, regional sponsored visa, which I briefly spoke about. Also, subclass 482 under DAMA. That also, DAMA is Designated Area Migration Authority. So that also.
But the eligibility criteria remains the same for an employer to become a sponsor?
Eligibility criteria is largely the same. Yeah. It's either SPS or labor agreement.
So the only thing that changes is the subclass under which they can sponsor a skilled worker. And moving forward, the pathway available for that skilled worker to become a permanent resident.
Yes, it's a little not as straightforward. For example, 482 visa can also be for regional areas under the DAMA arrangement. So DAMA, whenever there is a DAMA specific labor agreement for an employer in certain regional areas, then it is a 482, which is regional area specific.
What does DAMA stand for once again?
Designated Area Migration Agreement.
Can an employer sponsor someone for a PR? And if so, what are the various options one has?
Yeah, I briefly discussed about subclass 186.
Yes.
So an employer can sponsor 2 ways, or 3 ways rather. One is direct entry, which is when an employee or the prospective employee has a positive skills assessment, competent English and 3 years of experience. The employer can sponsor that person under direct entry, subclass 186. Then there is transition stream TRT, subclass 186. That is for those who are already on subclass 482 for a period of 2 years. The employer can then nominate the employee for this stream. It is not given. A lot of employees come to me and say, I have been with this company XYZ for 2 years and I now want PR. So they think they can just apply. And the fact is they cannot apply unless they have the blessing of the employer. Employer must endorse, by which I mean the employer must nominate the employee, saying, we are nominating him for this stream of subclass 186. Once the nomination is approved, then they apply for the visa.
This is
then
only for 186.
186. And then there is 191. 191 is a little straightforward. Someone who has been working with a regional employer for 3 years, they can go and apply for 191. They do not need nomination from the employer.
Have you ever had a client who's faced a challenge applying for a 186 because the employer refused to nominate their PR?
Yes, well, firstly, it's the employer that has to agree.
Yeah.
If they don't agree, that's it, end of story. So they have to convince the employer. Most of the employers are reluctant. You know why? Because once they get the PR, there is no obligation for them to stay, although it says that they must stay for at least 2 years. The employer, however, has to guarantee employment for 2 years after the grant of PR. And they must mention this in writing, preferably in the employment contract, saying this employment will be guaranteed for at least 2 years upon grant of the PR.
Okay.
So it's more onus on the employer. Hence, they are usually reluctant, unless, of course, they think the employee is very valuable, and then they have some kind of arrangement where every year they pay a huge bonus, and the employee cannot leave. He's very happy with the work environment and the remuneration.
But one would think that would be the case if an employer is trying to bring in someone from overseas or trying to sponsor a skilled worker. Wouldn't that be the case if you had a business and if you realize that you can't find or source the skill within Australia and you're trying to sponsor someone from overseas? That would definitely benefit your company. Wouldn't you want to do that? Make sure that they get their permanent residency and continue working for you in the long run.
Well, they can continue working on 482. They'll be permanently temporary.
Yeah, that is something that the government does not want.
But it is something that the employer can do, because I have seen a lot of cases where employees, they are very loyal, they swear on the book saying we will never leave this employer because they have done so much, and then once they get the PR, that's it, they're gone. And I'm sure some of those employers who are listening to me, they agree with me. But that doesn't mean to say that they should stop doing it. A lot of people do that.
So I guess we can wrap up the podcast on that note.
Mm-hmm.
Thank you for your time, Amitava, as always.
Thank you, Arun. Thank you, everyone, for listening.
Thank you for listening, everyone. And if you haven't subscribed, please subscribe to our channel. And we will see you next week. Bye.
Bye-bye.